All right, folks. We've heard the companion case to this case earlier, and I'm going to dispense with a lot of the procedural things that we would talk about on the front end because we've already done that. We've got the same lawyers involved here. However, they flip positions. We have a new appellant and a new appellee, but we will go ahead and call this case Mr. Hibner, and we'll proceed. Go right ahead.
Jerry Tomlinson et al. Versus Renea Garber et al.
All right, we'll hear from the appellant. There you go.
Thank you. Rachel Ratliff, again, representing the Tomlinsons on this matter. This time they are the appellants. Issues presented on review. I think.
Are you reserving rebuttal time?
No.
Okay. Go right ahead.
I think Mr. Boyd fairly adequately summed up the history of the case. This was a very tragic situation that this child found herself left in, but was, put in charge of both sides of her family. My issues on appeal are whether the Tomlinsons had that guardianship interest, which should have been required them to be part of the adoption proceeding, that they did have a guardianship interest, and therefore the adoption is void because their rights were not properly dealt with. And that in the event that the adoption is not just void outright, that the Garbers have perpetrated a fraud on the court, and that the adoption can and should be set aside pursuant to a Rule 60 in extrinsic fraud idea, and that they had other remedies. The Tomlinsons, had this proceeding gone as it should have, had they been properly included, they had plenty of remedies along the way. I think Mr. Boyd referenced the fact that they did not intervene in the adoption, that would have been the place to find their remedy, and they would have intervened in the adoption if they had been properly notified. They received no notice that this was occurring, and from the time the petition for adoption was filed to the time the adoption was completed was approximately just a few days. So
let me ask you a question, please, Ms. Ratliff. Where do you get their right to notification?
I go back to that order from the juvenile court. The statutory definition of guardian just says someone who is charged by the court to provide for care and supervision and taking care of a child. There are no magic words required by that definition. There's no nothing evidenced. The statute even says or specifically designated, which to me means there are other ways that guardianship relation can be created. The specific thing is that the guardianship definition does not say the person has to have custody. It doesn't require custody. It just says someone charged with taking care of and supervising a child, which the Garbers were clearly charged with that, as were the Tomlinsons. I think they had a
So you suggest that the mere right to visitation requires notice?
No, I do not. I understand that visitation does not equal a custody interest. I fully agree with that. But the charge to help raise that child is, I think, the turning point. The court that was a very specific language. However brief that order was, it was clear that the court intended for that to be indefinite, because they did close the case at that point and charged both sides with helping to raise this child in the absence of the parents. So that's where
I raised an interesting point about that being a final order in the juvenile court, but then you also acknowledge that the grandparents were granted temporary custody. Mm-hmm. So I'm curious, how could that be a final order?
I'm not certain, and I think there were some problems with that order, but again, I think the time to challenge it was back when it was entered. I think if there was an issue with it, that the Garbers had every opportunity to appeal that order, to challenge that grant of visitation, if they felt the Tomlinsons didn't meet the criteria. No one ever challenged it, and it went on for years unchallenged, and everyone followed the court order.
Well, could they have challenged it? Could they have even challenged it if it was not a final order?
I think the fact that the court didn't set any review hearings, I think, kind of made that a final order. There was never anything else done with it. That closed the juvenile case. And I think they could have challenged the visitation at any point, challenged that court order to modify or restrict the Tomlinson's visitation, just like you can a parent, cuts a visitation order.
Let me go back to what you said just a moment ago. You're suggesting that it's the language in the order, the charge, so to speak, of the court to the two people requesting custody or visitation, that they are to work together to raise the child.
Yes.
So following your thinking on this, that's what the court's got to look at, not only in this case, but in every case going forward regarding someone claiming a right to notice in an adoption case. You've got to look at the underlying order.
I think so.
Okay. Was the relationship of the father ever established in this case, or was it just agreed to and accepted, or how did that work?
I believe it was agreed to. I don't believe the child was, I think she was only she was very, very young. I don't know how much time there was to have that established. And there was nothing in the record. I did not handle the trial level case, but there was nothing in the record showing that his paternity was established. Which is another reason I think if there was a time to challenge it, it should have been, back there.
Okay. So let's talk about your fraud claim here.
Certainly.
Tell me how this is fraudulent.
I think the decision as to whether the Tomlinsons had an interest should have been a decision for the adoption court. I think that was not, all of the adoption petitions that we do require notice to be given to the court of anyone else with an interest. And most of them even say that of no one with any other even visitation interest. The Garbers were well aware that there was a visitation interest hanging out there. And, just to get a clear adoption, that should have been a decision brought before the adoption court for them to make.
Ms. Ratliff, is the adoption petition a part of our record?
I believe the final decree is, and yes, it is. It was made an exhibit when the Tomlinsons filed their petition to set it aside. They included a copy of that petition where the Garbers signed and swore that they knew of no other person with any interest in the child.
And did you raise this argument at the trial court level? Or I understand you weren't counsel at trial. Was this argument raised as to fraud or any of your Rule 60 argument, anything like that ever brought before the trial court?
Not specifically as fraud, but that they did purposefully omit information. And in the case law, there's a case specifically out of Greene County, Harmon versus Swartzel. It was a 98 case where Rule 60 was not specifically raised by a mother. She filed a petition to correct an adoption, but the court went ahead and considered it under what she had filed it as well as Rule 60 because of the nature of her allegations that something fraudulent had occurred. And I would ask this court to do so again in this matter. I understand that there's no, collateral attack after a year pursuant to 36-1-122B2. However, the context of that subpart has to be looked at where it is. It falls in between two other subparts that reference things like clerical errors, like accidental acts, or omissions by Department of Children's Services, not private entities. I don't believe that statute can be construed as a mechanism to absolve purposeful omissions of information by private individuals. And certainly it shouldn't be meant to cover fraud as long as you can cover it up for a year. I believe that this should have been a question for the adoption court as to whether the interest for the Tomlinsons rose to the level of guardian. There are several cases where the court has, had there been an intervening petition, there are several cases where grandparent versus grandparent in an adoption, generally, if the court grants adoption to one, they're at least going to look at or consider visitation to the other set of family members. And again, I think this goes back to my prior argument that the Tomlinsons fall under that, including but not limited to part of the grandparent statute, that they have acted in that capacity. They've continued to have that kind of relationship with the child and should have been able to be considered. Their interests should have been brought before the court based on that language from the juvenile court that I believe charged them as guardians for the child. They had valid visitation pursuant to that juvenile court order. The Garbers are relying primarily on a In re Matthews case to say that the juvenile court order should have automatically just been invalidated. However, In re Matthews pertains to a matter that was actually pending in the juvenile court at the time an adoption was filed, and the court in Matthews stressed that juvenile court can't take jurisdiction away from the higher court and hamstring permanency for the child. But this was not a pending matter. This was something that had been decided for well over a year, their visitation. And so the filing of the adoption didn't automatically obliterate, the prior court order. It was still valid through the grant of that adoption at least, and should have been taken into consideration.
The arguments that you made to the Chancery Court here, first of all, you argued that the statute gave a right to notice. Is that correct?
Yes.
That your client should have been considered guardians or should have been considered as guardians, and that they were entitled to notice. Did you also make the fraud argument to the Chancery Court?
The issue was raised. It was not specifically labeled a Rule 60 issue, but the allegations in the petition were that they did purposefully omit the information about the Tomlinsons to the detriment of the Tomlinsons, and that they, by swearing on that adoption petition, that they knew of no other parties with an interest, that was in essence fraud.
Was there an actual hearing conducted, or was it just an argument?
I believe it was just an argument. There wasn't the transcript doesn't show a ton of testimony on that issue as you would expect from a full hearing. It was primarily just argument by the attorneys.
Was there any testimony introduced?
As to the issue of them being omitted as far as notice, I don't believe there was.
Okay. In fact, was there any testimony introduced on any part of this case?
Very minimal. I believe there's a segment of the transcript where Mr. Tomlinson or not Mr. Tomlinson, I apologize, Mr. Garber kind of joins in the argument. I don't think it was technically sworn testimony. He wasn't questioned by the attorneys. There's just a part where he kind of joined in at the argument and went on at length about his awareness of the adoption statutes and how they work. And it seemed that he had done a lot of research and, should have understood that to have a clear adoption, they should have taken care of the Tomlinsons' interests.
Did the trial court rule again that the statute that you're relying upon to say that your guardians or say that your clients are guardians was inapplicable, or did it just simply reassert that it had already decided that issue once?
Pretty much. They just reasserted that that the time that had passed, that there was nothing allowing a collateral attack on that adoption, and that because they were no longer related to the child, that they didn't have standing anymore.
Okay. Thank you.
You're welcome. I'll go ahead and turn it over to opposing counsel.
Okay, all right, thank you. All right, Mr. Boyd, we will hear from you, please, sir.
Thank you, Your Honor. To me, this whole case revolves around the fact that 1 year after this adoption was granted, that this adoption became final and can't be attacked. I think that, to me, is a very critical point to this. The second thing I think is a very critical point is the issue of the fact that there was never any kind of proceeding of intervening petition on the part of the Tomlinsons trying to raise the issue of the fact that a visitation would rise to the level of a guardianship or custodianship, particularly under TCA 37-5-103-12. It specifically defines what a guardian and guardians, co-guardians, or custodians are found. It just specifically says it's got to be done by a court, and it's got to be granted to a individual or an entity specifically, and none of that has occurred in this case. And
Let me ask you a question, Mr. Boyd. There's no question that your clients failed to give Ms. Ratcliffe's clients notice of the adoption, is there?
Well, this is an argument that I feel, Judge, is really is not really fair, because under the law they're not entitled to notice to beginning, because they're
humor me. I'm just asking a specific question. Was notice given?
Well, let's put it this way. Notice, whether it was given, it was factually known. Now, I don't think
I'm not sure factually known what, that the adoption had occurred,
that the adoption had been filed, and that the Tomlinsons knew it, and they chose not to intervene. I don't feel my clients had an obligation to advise them, because they weren't parents and they weren't grandparents. They have no right under the statute to receive notice. So I feel like that the issue of notice to the Tomlinsons is really moot, because of the fact that they're under the statute, they're not entitled to notice. Now, I realize there was an issue about whether or not there was visitation, but I can't remember exactly when the visitation was granted as opposed to the time the adoption was filed. And I'm concerned about the lack of, with the fact that the adoption was filed before the actual visitation was granted in juvenile court. It was all being done about the same time. And so I don't think, even though there may not have been notice to the Tomlinsons about their visitation, I'm not sure that happened. The visitation was granted before the adoption was filed. I can't remember the exact time on that.
We posed the question to Ms. Ratcliffe about the paternity or the parentage of the father being established. Was that just accepted, or how did that work?
Your Honor, the court ordered.
I'm sorry, I can't understand you. Apparently, we're having a little communication problem. Could you repeat that, please?
Let me see if I can do a better job. There was a DNA test, and the putative father was found to be the father.
Okay. Is that in the record?
That's accepted.
That's in the record, or?
I can't remember if it's a record or not, but it is accepted. There's not a dispute on that.
Okay. Thank you.
Okay. So, to me, Your Honor, and I don't want to, beat a dead horse to death on this thing, but the truth is there's no guardianship and there's no custodianship created. And because of that, the motion to dismiss should have been granted at this point, because of the fact that if you apply the statutory language in reference to the definition of a guardian and custodian, and also the definition of the fact that under TCA 36-1-121F about who has a right to decide what continued contact after the adoption is granted, the adoptive parents have, then if they don't have that right, then they ought to have the same right as a natural parent. And a natural parent has the same right to stop a visitation except with the grandparent. And in this particular instance, there's been a considerable amount of litigation with reference to this continued aspect of visitation, when in fact, there is no visitation by estoppel, and there's no adoption by estoppel. And the fact that they granted visitation and want to cut it off, that's the parent's right to do that, except for the grandparent. So we believe from that standpoint that the motion to dismiss should have been granted at that point, because the Tomlinsons never challenged it on a intervening petition in the trial court, and now they want to challenge it now, which we think it comes too late at this point. So if there's other questions, I'll be glad to try to answer them. But I think based on what was stated in the previous argument and what's at issue at this point, I think the statute of repose, from the standpoint of adoption becoming final after 1 year, takes away the arguments that the Tomlinsons have made with reference to any kind of continued efforts at visitation. And as far as there being a fraud on the court simply because they say that they weren't given notice, the issue is they weren't entitled to notice at that point. They were not closely related enough for notice to be granted, and they're not grandparents. They were an aunt and uncle, and so I feel that all of that should have been granted. The motion, they had no standing, and the motion to dismiss should have been granted. I have no further argument.
All right. We certainly appreciate both of your arguments. This is obviously a procedural quandary, and we appreciate you working with us and making your arguments as you have. We will do our very best to get you an opinion as quickly as possible. I want to again thank Mr. Hivner for all his hard work here and the AOC staff. And we'll be in recess then until the call of the next case, Mr. Hivner.
Thank
you,
you, Council.
Counsel.
Now in recess until 11 a.m.
Thank you.